76.
76. 76.
Yeah, we did 76, right? Yes. So 77 is the next.
Oh, okay.
Let's get the recording going now. Okay.
Bro, I did not bring my book, bro. Yeah.
Mine's was on my computer.
Oh, okay. Got that.
Yeah, share.
Sure, thank you. Appreciate you. Do they have friends? No, just. Alright.
Okay, we should be in good shape now. Looks like we're recording. All right, good morning. So we're starting off on problem 77. That's what I have. And I just want to make sure the previous case, Kunkel, I wanted to just touch base about that one. In the case, we have Hoaxie Feeders and Sprague National Bank, and the issue comes down to, does a purchase money security interest in inventory where there is no notice, who has priority? And the essence of the case is that there is, even though no notice had been given, the debtor had not, the buyer had not yet, the debtor had not yet received possession. So the time for notice had not started to run. So therefore, the seller was still in possession of the inventory. They had not delivered it to the buyer, who was the debtor, and so therefore the obligation to provide notice had not started. And that is a literal reading of the statute, which requires that the notice be given with before delivery. So we're looking at 324 subsection B, and it requires that the purchase money security interest is protected when the debtor receives possession, and the purchase money secured party sends an authenticated notification to the holder of the security interest, and then part 3, it's received within 5 years before. And the 5 years before is the debtor receives possession. So since the debtor has not received possession, and the seller is still in possession, so they have perfection that way, there is no running of the clock for delivery of notice. So the court reads the statute exactly as written, and there is no time where the purchase money secured party loses. Okay? That was the Kunkel case. I don't think we talked about it before we left, so I just wanted to make sure we understood. That is the essence of the case. 9324 requires that a purchase money secured party in inventory provide notice to the other secured party in inventory before the debtor receives possession. And here the debtor never receives possession, so therefore the clock doesn't start to run under 324B. Okay? That make sense? So just 324, read it according to its, understand that it's applied literally according to its terms. So let's go to problem 77. And we have Hands Racing Equipment bought inventory from Standard Auto Wholesalers, which also took a purchase money security interest in the goods, and they also borrowed from Matching Dishes National Bank. So we have two competing secured parties. And the question is, between those two, who has priority? Who can describe the difference? Well, first, are they both perfected money secured parties? Are they both lenders that help the buyer acquire the collateral? Acquire the inventory. So we have two secured parties. We have the company that sold the inventory, and then a bank that lent. So I think it's right. $3,000 was the purchase price. $1,500 of it is credit from the seller. $1,500 is credit from the bank. Both sums are used to acquire the inventory, so therefore we have a purchase money security interest for both parties. Okay. Remember, this is inventory, so 9(3)24 normally would apply. A purchase money secured party has priority, but they're both purchase money secured parties in inventory. Who wins?
Vendor.
Yes. When you have a non-bank purchase money secured party in inventory and a seller purchase money secured party and a non-seller purchase money secured party in inventory, the code prefers the seller. The vendor beats the other non-vendor.
Would you repeat that?
I will try. So we have two parties who are purchase money secured parties in inventory. They both gave each other notice, so they met 9(3)24. If they screw up 9(3)24, then they don't get that priority. So they've met the standards of 9(3)24, B. But they both are purchase money secured parties. So we've set up a competition between two parties that are trying to get the advantage of 9(3)24B in inventory. Who wins? And how do we know that the seller wins? What section tells us?
9(3)24G.
Yeah. G. G is essentially the vendor beats the non-vendor. We like sellers over banks. That's essentially what this is. So if you're the seller of inventory, you're going to have super priority over a non-seller of inventory. What if we have two purchase money secured parties that are not sellers? Who would win under that circumstance? 322A, first to file or perfect. So this problem was setting up the circumstance where you have two secured parties in inventory that are each vying for the super priority. If one is a seller, they win. If neither is a seller, or they both are sellers, first to perfect under 322. Then the special rules go away, the normal rules apply. 9(3)24G, is it 2 or B? G2, right? Yeah, G2. 9(3)24G2. So, before we go anywhere, I just want to make sure. For most sales of goods, it's 9(3)24A. Purchase money secured party is going to be protected, as long as they follow the rules of 9(3)24A. Special rules apply for inventory. Okay? 9(3)24B. And then, what do you do if you have competing interests, conflicting purchase money security interests? G. Okay? If more than one security interest qualifies for priority, under one of these rules, vendors beat out non-vendors, and if it's equal, first to file or perfect. Okay? That's what G is saying. Just don't forget the special rules for inventory. That's a key point I want to make here.
Does the non-vendor still have priority over other interests?
Yes.
Besides the...
Yeah, you still have super priority. You might lose out that other purchase money secured party, but you beat everybody else.
You said it was G?
Yeah, isn't that what it says? G?
Yeah.
G says conflicting purchase money security interests. That's what G says. 9(3)24G. That's 77. We're all good on that? So 9324 is what happens when you're a purchase money secured party, a set of rules about how you take care of it. Remember, if it's consumer goods, you don't have to file unless it's a car. Cars are special. You have a certificate of title, you have to file a certificate of title. Right? But most cases, sale of goods, 9324A, purchase money secured party beats other secured parties. B, if they're inventory lenders though, inventory lenders have special protection, so the party claiming purchase money priority has to do an extra set of steps. That's 9324B. If there is a competition between secured parties, then it's 9324G, purchase money secured parties. And that's purchase money. Everybody good with that?
The G only applies for inventory.
Nope. No, take a look at, read the statute. If more than one security interest qualifies for party in the same collateral under subsection A, B, D, or F. Yes. I hear mumbling, so I want to make sure before we move on.
Can we just like go over G1?
Yes.
That language
A security interest securing an obligation incurred as all part of the purchase price of the collateral has priority over security interest securing an obligation incurred for the value given to enable the debtor to acquire rights in or the use of collateral. That is confusing language for the seller's perfected purchase money security interest beats a non-seller's purchase money security interest.
Okay.
The vendor beats other secured parties. The vendor beats everybody, other people. We like sellers. That's the rule of G1.
And that's only for inventory?
Nope.
Oh, for inventory.
G applies to all collateral, all purchase money collateral. Okay? It's just in the problem we have in the book, they happen to be inventory secured parties. Secured parties with collateral interests in inventory. So they had to do the 324B stuff. You still have to follow 324B to get super priority as a purchase money lender if it's inventory. That doesn't go away just because it's G. Right? So if you screw up and don't give the notice, you don't have super priority at all, so there's no competition. Got it? Does that make sense? So if in the problem in 77, if one of the two had not sent notice, do they get priority in their purchase money security interest? No, because they didn't send the notice. You always have to do everything required of you to get that super priority. Under 324A, do you have to file? Yes, within 20 days after possession. If you don't do that, are you entitled to the special priority rules? No. So if you're not entitled to the special priority rules, then 324G doesn't apply. So if you file on the 21st day, you are a regular perfected secured party, no extra priority. That make sense?
So if they fall under G for a situation, the G's explained, then the non-seller has priority? Is that basically what it's saying?
Well, there has to be a competition
Right,
in G between
Right.
two parties who qualify as purchase money secured parties.
right.
So give me the hypothetical you're asking about.
If that does occur.
So you
then
have
it's
two
the
parties,
It's a non-seller that would have. the
so
priority.
two secured parties who
Mhm.
both are purchase money secured parties.
Uh-huh.
What's the answer?
It would be the non-seller, right?
Yeah, so you have two non-sellers though. You just told me
Uh-huh.
neither one is a seller.
I guess whoever.
G2. That's exactly right. Yes, your answer is correct. G2. If we don't have a seller involved, or if they're both sellers. Hard to imagine, but you know, if there's not a competition that involves a seller,
Mm-hmm.
if they're of equal status, G2 applies, and it's just the regular rule, first to file or perfect.
Right.
Okay? So, purchase money security interests. For now, we're looking at 9324 and all those rules, and we've concentrated on A, B, and G. Okay? Problem 78. The key to this question is that a consignor is a purchase money secured party. Now remember, consignments under 9109 are included, right? So if we go back to 9109, we see 9109 A4, a consignment is included. So we have an artist, creates an artwork and wants to sell it on consignment at a gallery. That artist is treated like a purchase money secured party under what's the rule that covers it? 9324B, right? Consignor equals a purchase money secured party must follow 9324B. I'm sorry, 9103D tells you that you're treated as a purchase money secured party. So consignors, special rules, you're treated like a purchase money secured party. So what is that? Is that good for this? If you're the artist, is being treated as a purchase money secured party a good thing?
Yeah.
Why is it a good thing, Natalie? You get super priority, but what do you have to do?
You have to give notice.
Well, is it inventory to her?
Oh, that's where I'm confused.
Okay, so what does she have to do in order to get super priority?
Does she have to file it in 20 days?
Yes.
So, within 20 days of what?
She has to file, oh, sorry, it is inventory, right? She has to
Okay,
do the whole
that's-
notice thing, yeah.
Okay, that's
Yeah.
what I was confused.
9324B. She's selling her art. So if she's selling it, what is it?
Inventory.
Yeah, okay, so we characterize the collateral in her hands, it's inventory, she has to file, she has to give the notice under 9324B.
Okay. That makes
Does she get, in the problem, did she do that?
No.
So what does that mean?
She loses.
She loses. The artist who sells on consignment but doesn't provide the notice and file the financing statement as required by 9324B loses to the existing inventory lender. So it's both good and bad, right? She's a consignor, so she gets the super priority benefits of 9324, but she's a consignor in inventory, so she has to follow 9324B, which requires that she perfect before delivery and provide notice. Does she do any of those things in the problem? So she's essentially an unperfected secured party. But even if she had done them late, she still loses to OMB, right? Or no, who's the bank in this case? It is OMB, yeah.
So would a consignment shop always be inventory, like they would always have to follow inventory rules?
Well, so the shop is selling stuff.
Yeah,
Yeah,
So-
and she's the artist selling stuff.
yeah,
it's
so
gonna
it
be-
would always
yeah.
be inventory.
Probably would be, yeah. So now, here's the question. How do we help her? Is there a way to save her? We looked at this earlier in the semester. Are there rules that take consignment sales out of these priority rules?
Yeah, like if she put like a sign up that said that was, there's something like, you have to put a sign up that says that these are consignment. This isn't actually the inventory of the art gallery.
Yeah, now remember, look at 9102A20A3. Let's look at the definition here. So 9102A20. A3. A consignment means a transaction, regardless of the form, in which a person delivers goods to a merchant for the purposes of sale and is not the merchant, so not her, but the store, is not generally known by its creditors to be substantially engaged in selling goods of others. So are most art galleries generally known to be in the business of selling art of others?
Yeah.
Not a consignment under Article 9, therefore, Article 9 doesn't apply. She wins. If we can establish 9A 102 A20, 9102 A20 A3, that it's a merchant who is known to be in the business of selling. That's the big one that I want.
So if it's not a consignment, the bank wouldn't be able to take it?
Right.
Okay.
She owns it. It's her property. And it's not subject to Article 9. It's not a consignment subject to Article 9. Okay.
912, that's the definition.
And there's also, if it's consumer goods in her hands, it doesn't apply either. Because it's not a consignment. It doesn't fit the definition of consignment either. Right? Consignment means a transaction regardless of the form in which a person delivers to the merchant for the purpose of the sale, and the merchant deals in the goods of the kind under the name, is not an auctioneer, is not generally known by creditors, yeah. And then you look at 920, and then subsection C, the goods are not consumer goods immediately before delivery. So if she's a consumer, so it just happens to be an artwork she has, or it's artwork we're treating as for personal, family, or household purposes, it's not a consignment for Article 9 purposes. Okay? I don't want to go too fast. I want to make sure everybody's good on this. The definition of consignment's important. If it's not a consignment, it's not an Article 9 transaction. It's not an Article 9 transaction as a consignment if A, the merchant is known to be selling goods as a consignor, or B, in this case, they're consumer goods for her before she consigns them as the artist. She painted it for personal use and then decided to sell it. So it's consumer goods to her. She's not in the business of, she's not a commercial artist. Okay? All right.
Can I ask you a question?
Of course.
What, so I know it might be going backwards, but on inventory and livestock under PMSI, it says the PMSI creditor has to perfect before the debtor obtains possession.
Yep.
How do they perfect? I forget.
File.
That's it?
Yeah. Or possession.
Okay.
Goods can be perfected two ways, either filing or possession. Either one works. 9.3.12.
But if it's a PMSI in, equipment, software, or a farm product that's not livestock, then it's automatically perfected?
Well, so only consumer goods is subject to automatic perfection forever. There's temporary automatic perfection if you file within 20 days after, under 9324A. Yeah,
Okay.
yeah. But if it's inventory, then you have to do the notice and file, do the perfection
So-
before the debtor receives possession.
Oh, it's not, I meant, okay, so that's just consumer goods, that's the wrong, okay.
Okay.
Consumer goods auto perfect.
Yeah,
Okay.
9309A.
One.
Yeah, 1, sorry.
Okay.
93091, consumer goods are automatically perfected upon attachment.
Okay,
Yeah.
thank you.
Yeah, no problem. Good question. I know it gets a little confusing. This is why definitions are so important. What is the collateral is a key question here. What is it in the hands of the debtor? In this case, what is it in the hands of the consignor, right? The person consigning the goods. If she's an artist but she creates art for personal use, then it's not a consignment covered by Article 9. Consumer goods are not part of this. If she's a professional artist, it might also fall outside of a consignment because the merchant, the gallery, might be in the business of selling consigned goods, and and everybody knows that. So therefore it falls out under the definition of consignment as well. Then it's not an Article 9 transaction. All right. Problem 80. We're skipping problem 79 and 81. In reviewing it, it was just, I'm not ever going to test on it, so on the control of investment property or letters of credit. Be aware that it's out there. I don't think the bar tests on this either, so I think I'm being consistent with that. But they will test on deposit accounts. So what is a deposit account? It's a bank account, right? What we would commonly call a bank account is defined as a deposit account under Article 9. So, How do you perfect a security interest in a deposit account? There are, and who has priority? So, 9104 defines when control, what control is, right? So if you look at 9104, we see that control of deposit account, right? A secured party has control. This is how you define control. Why is that important? We see under 9.312B that except as otherwise provided in 9.315C and D for proceeds, we haven't done proceeds yet, so don't worry about it. We will get to that later in the course. A security interest in a deposit account may be perfected only by control under section 314. So for deposit accounts, you get control as defined in 9.104. You can only perfect under 9.312B. So filing does not cover the security interest, the perfection of a security interest in a deposit account. Doesn't work. Have to have control. 9.314 tells us about the how you get perfection by control, and particularly under 9.314B, the time of perfection. Okay. So these are the rules about perfection by control. And then we go to section 9.320, 320, is it 2 or 3? Can't read my writing here. 22. 9.322. No, that's not, 9.322, no, shoot, sorry. 327, sorry, couldn't read my writing. 327. 327 tells us the special priority rules in deposit accounts. Okay, so those are the sections together that we have to understand on who has priority over a security interest in a deposit account. What is a deposit account is defined in 9.102. The way you get control is defined, or where control is 9.104. 9.312B, you can only have perfection by control, 9.312B. 9.314 tells you what is perfection by control, the rules about perfection by control. And 9.327 is the priority rule. Okay, so these are the sections we're going to read together. 9.104 lists 3 ways how do you get control over a deposit account? 3 ways under 9.104. Right? You have control over a bank account if you're the bank. So if ONB is also a bank that takes deposits and the debtor has a bank account with ONB, then ONB has control over the debtor's bank account. They are the bank. The lender has control over any deposit accounts in its in that bank. 9.104A. 9.104B, you're another bank. You have a contract with ONB. And ONB and the depositor and the other bank agree that this bank will have control. Or C, you become the holder of the bank account. So the name changes on the account.
So in that case, it would be, somebody offers up their deposit account as the collateral, and they, when the contract with you, they put your name on the.
As the secured party.
As a secure party, and they put your name out on the name of the bank account.
Yes.
Change the name of the bank account to the secured party.
Yes. Yeah. Okay. So these are all the rules. So let's take a look at the problem on problem 80. Computer World borrows money from Investment Bank of America, which will grant a revolving line of credit secured in part by the bank account that Computer World maintains at Last National Bank. So, is Investment Bank the bank in this problem? Who's the bank? What's the name of the place where the deposit account exists? LNB, okay? So IB wants to be the secured party. LNB is the depositing bank, right? Bless you. Cool. So, do they have this? Can they get control this way?
No.
No. They have to become LNB. They have to tell the depositor, move your bank account here. They don't have that. Great. So what are the other two ways they can have control over the debtor's bank account? And the three parties to this contract, who are the parties to the contract?
And the two banks and the debtor.
The two banks and the depositor. So LNB, IB, and what's the name of the debtor in this case?
Computer World?
Computer World. Those three parties have to have a contract. Makes sense, right? Okay, good. What's the other way?
Computer?
What do you ask Computer World?
Part of your name.
Switch names on the name on the account. Okay? So those are the two ways. That's the first part of this. They're not the bank, so they have two choices. Contract or get their name on the account. Which of those two is better? Be the bank is the best. Is that the best? Let's take a look at 9327. So 9327 tells us which is the best.
The last one. If you're
The
reading-
last one. Why is that one the best?
It says that if you have control over the account, you have priority.
Well, all three of these are controlled.
Okay.
So, but what form of control?
Equity, I don't know. Like, it would be it's your property. I know you have contract rights, but if you're the account holder, like, it's yours. Like, you don't have to go.
9327-4. A security interest perfected by control under 9104A3 has priority over security interest held by the bank in which the deposit account is maintained. This beats this. 9327-4. Take a look at 3. A security interest held by the bank with which a deposit account is maintained has priority over conflicting security interests held by another secured party. So, being the bank is the next best thing, and this is the least best. Okay? Otherwise, under 2, except as otherwise provided, security interest perfected by control under 9314 rank according to priority and time. So if you don't have a special rule that protects you, it's just when did you become the bank? Or sorry, when did you get your control over the bank account? Okay? A security, and then under 1, a security interest held by a secured party having control of the deposit account under 9104 has priority over conflicting security interest over a party that does not have control. That is dealing with proceeds. We have not studied proceeds yet. We will come back to 9327-1 later. Okay? So the general rule is order of time, but there are certain, under 3 and 4, certain kinds of control is better than other kinds of control. Okay? And that's basically question 8. Of the methods listed, there are only 2 available. Get a contract or change the account name. Obviously, the latter is the safer course, since with the, if you control the bank account, you prevent Computer World from draining the bank account. It's your bank account. You control it. That's the best. You have control over the flow of cash. That's what they're looking for. Deposits accounts are bank accounts. These 4 sections are the sections you need to understand. How you get control, that only control is possible for perfection. The rules about perfection through control, and then priority with respect to deposit accounts specifically. Okay? Those are what the 4 sections deal with. 9104, 9312B, 9314, and 9327. I went a little fast there. Well, I should say, did I go a little too fast, or do we feel like we get it? Everybody good? So I want to move on to buyers. Everyone is so happy to be here in class on a Friday morning. It's going to rain anyway. Wouldn't you rather be inside where we've shielded you from, the gray clouds outside? There's no natural sunlight in here. It's one of the worst things about this building. There are no classrooms with any windows. It's like a bunker. It drives me crazy. That's why I became associate dean. I have some of the best windows in the school. That's why. The rest of the stuff, I don't even do my job. I just sit there at the window and look out. Yeah, that's not true, obviously. Okay,
I'm telling you.
buyers. So I want to start with the case before we go to the problems, because the case exhibits the general rule about what happens with security interests when the collateral is sold. So Barnes is the seller in the case, right? Barnes, sorry, we're skipping problem 81. We're going to buyers. I'm skipping over problem 82. I'm coming back to it in a minute, okay? So I want to talk about the case International Harvester versus Glendenning on page 202. All right, so Barnes is the seller of the tractors, right? Yeah. Yeah. Are they tractors? Yeah, they're tractors, right? Okay. So the problem here involves the sale of tractors that have an existing security interest held by International Harvester. Now, International Harvester is the seller, so are they an ordinary secured party, or do they have an extra benefit?
PSMI.
Yeah, they have a purchase money security interest. Now, as it turns out, the purchase money security interest doesn't always matter when we have a dispute with buyers. Up till now, we've been talking about priority battles, about who has priority, right? But with buyers, the question isn't who has priority. It's, does the security interest exist at all? Because under the rules we're going to study, we're going to see that buyers can cut off perfected security interests. Okay? Buyers can cut off perfected security interests and take 3 of them. So this isn't really a priority battle. This is an all or nothing battle. Either the goods are subject to the security interest or not. Okay? If they are, obviously the prior interest wins, and it's still collateral and it can be foreclosed on. The reason I want to start with this case is, what's the general rule?
That it passes to the buyer, right?
9315A1. A security interest continues notwithstanding the disposition of the collateral. That's the general rule. That's where it's the starting point for the analysis. Okay? Notwithstanding the disposition of the collateral, the security interest continues. So, if a buyer can't cut off that security interest, they take subject to it, which means that the secured party can foreclose. So this is a little bit of a different battle. It's not who collects first, who collects second. It's either, is there security interest or isn't there? That's the battle with buyers, okay? Why does Glendenning lose in this case? We go outside of Article 9 and we look at the definition of buyer in the ordinary course, right, Natalie? That you were going to volunteer?
Yeah, that's what I was gonna say, they said that he was not a buyer in ordinary course because there was bad faith or deceit in the purchase, so he didn't qualify for the.
Exactly. And if we look at the definition of buyer in the ordinary course in 9201B9, buyer in the ordinary course means a person that buys goods in good faith. What was the evidence that proved that good faith was missing here?
I don't remember.
It doesn't matter, I'll go over it. The essence of it is there was never any attempt at good faith. I mean, it's just like, this is exactly the circumstance that should destroy buyer in the ordinary course. Glendenning knew there was a security interest, created a fake transaction, claimed to trade in other old tractors with the stated intent of essentially helping Barnes out. He admits to this in court. This never happens. This never happens. This case is great. This is an example where the person goes, oh yeah, I was totally trying to cheat. That's the essence of his testimony, right? And he goes, but I'm still a buyer in the ordinary course. And the court comes back and says, look, this is ridiculous. All the evidence shows that this guy knew what he was doing was not fair, right? Now, it is a curious case because if I'm right, didn't the bankruptcy court the appellate court overturned the district court. The district court said, yeah, we got good faith. We don't care. And the appellate court goes, what? You have uncontested testimony by this guy that he knew and did it anyway. He knew that he was cheating the bank and did it anyway. He did not qualify as a buyer in the ordinary course, so therefore 9315A1 applies. The security interest continues, and what does that allow? Well, the problem is he's already sold them, right? He went to Louisiana and he sold the tractors already, so all he has is cash. So what does International Harvester get? They don't get the property back. What do they get? Damages for the value that they would have received. Does International Harvester say that's a bad deal? No, they're like, this is fine. We just as soon have the cash. They don't have to sell it now. They don't have to sell the tractors. They just get a check from Glendenning. In order to be a buyer in the ordinary course, you have to have good faith. There's other requirements too, but that's a big one, right? You have to be a bona fide purchaser for value, in essence. Okay. Yeah, okay, so on. All right. So that's the case. So let's go back to problem 82. 82 is, when are you a buyer in the ordinary course? So, Betty Consumer bought a television from Distortion TV. A month later, Distortion went bankrupt, and Octopus National Bank shows up at her door and says, I want the TV. What is her legal right in this circumstance to say to the guy from ONB? Using only words that are appropriate for a G-rated movie.
She's a buyer in the ordinary course.
I'm a buyer in the ordinary course, and therefore leave because why? That's right. I agree with that answer.
Because the security interest is gone. It's not. Yeah.
And what section of the statute tells us that the security interest is gone?
9302 or 1-201B9. The definition. I don't know. I use 9-302. I put them all in there.
You put them all in there?
Yeah, my notes are organized.
Is that the section 302? I think 302 is about choice of law, isn't it?
320. I mean.
320.
320,
Yeah.
my bad.
You just go first. Good. 320. What does 320 tell us? 320A. What does it tell us?
Buyer in the ordinary course.
What Dimitri just said.
Buyer in the ordinary course.
Other than person buying farm product for a person engaged in I don't know.
Now remember, you gotta meet all the requirements of 1201B9. It's not enough to just be a buyer. You have to be a buyer in the ordinary course. You have to have good faith. You have to take possession, right? But if you meet the standard of buyer in the ordinary course, you take free of the security interest. Created by who?
The seller.
Okay, we're gonna come back to this, but that's a key part of this, right? Here, it's the store, Distortion TV, granted a security interest in its inventory, and then buyer comes in and buys the TV. Does the buyer get the TV free of the security interest? Yes. And I want you to flip to comment 3. Second, third sentence says, this subsection A applies primarily to inventory collateral. Doesn't say exclusively, but primarily. It's basically someone goes to the store and buys from the merchant. Why is it inventory? Why is it only mostly inventory?
Goods for sale, like.
Well, let's take a look at the definition of buyer in the ordinary course. What does it mean to be a buyer in the ordinary course?
Person that buys goods in good faith without knowledge that the sale violates the right of another person. Is that kind of what you want?
Keep going.
Okay. Person in the goods in the ordinary course from a person
Yep.
other than a pawnbroker in the business of selling goods of that kind.
So the definition of buyer in the ordinary course means you have to go to somebody who's selling goods of this type. If they're selling goods of this type, what is the collateral in their hands? Inventory. Okay? That's why comment 3 says this is usually a circumstance where you have a buyer buying from inventory. Do you have to be a consumer buyer?
No.
No! Exactly right, Dimitri. Any buyer. It doesn't matter who you are as a buyer. What matters is the seller in the business of selling these goods? Okay? Great. That's 9320A. That's the standard rule. You go to Walmart, you buy a TV, you take free of any security interest that Walmart has created. Because Walmart's in the business of selling TVs. Brilliant. Done. None of us ever have to worry about, a security interest. If you buy from Amazon, we don't have to worry about any security interest created by Amazon. All right. That's the essence of a buyer. And that's why it's so powerful. It cuts off the security interest. You take free of it. Okay, question B from this question. It says, would it matter if she had known? And the answer is no. Look at the definition of buyer in the ordinary course. Again, I'm going back to Article 1. Does it say you can't know the existence of the security interest? What can't you know? That it violates the security interest. Yes. Doesn't matter if you know. Part C. Would it matter if she knew that it was a liquidation sale and they were going to file bankruptcy?
I said no.
No. You can't know that it violates the security interest, but that they're going to file bankruptcy is irrelevant. It's not in the definition, right? You can't know they're about to become insolvent or that they are insolvent. It's not part of the test. So the only thing you can't know is that that it violates the security agreement.
So you could think that the secured party and the debtor had contracted to sell the goods in order to maybe pay off the existing debt. That you would be under that assumption. That would be fine because you don't know it violates the security agreement.
Well, one, if you don't know, you don't know. If you don't know, it doesn't matter. If you know, it doesn't matter, and it doesn't matter if you know that they're using the money to plan a trip to the Bahamas. Who cares what they're doing with the money?
So you specifically have to know that it violates the security agreement.
And that's what the statute says.
All right.
So that's the limited circumstance. You have to be aware of the actual terms of the agreement that it will violate the terms of the agreement for them to sell the collateral to you.
Is the only way for them to say that they know that it violates the sale, and the problem is to say buyer knows that this violates the sale.
And how would they prove it, right? They still gotta prove it. What does it mean to know something? This is a defined term in Article 1. And I'm gonna see where it is. What is 1202? So take a look at 1202. What does it mean to know something? Sorry, wrong page. A person has notice, right? Knowledge means, this is B, 1202B. Knowledge means actual knowledge. Knows has a corresponding meaning. What is actual knowledge? As opposed to fake knowledge. I don't know. But it sounds like an incredibly high burden. I think the only way they could prove it is, like, let's say you're the CFO of Walmart, and you know that Walmart signed an agreement that says they can't sell their TVs anymore. They need specific permission to sell them. Yeah, I think you know it, and I think we could probably win on that case. Anything short of that, I think you'd have to prove that the document had been put in front of them, and they read the provision that said no sale is legal. Yes. You had a question? You wanted to comment? Yes.
So,
Okay, we're good. So that's problems 81. Pretty straightforward. Sorry, is that 81? 82, sorry. Yeah. Okay, so I did the first case first, the case first, because that's the general rule. If you can't prove you're a buyer in the ordinary course, 9.315 applies. The buyer takes subject to the security interest. If you can prove you're a buyer in the ordinary course, you take free of the seller's security interest. Of a security interest created by the seller. That's the best way of saying it. Okay. 83.
are we gonna do the layaway problem?
Oh, sorry, yeah, Part D, sorry. The rules in Article 2 and say that the layaway is you take free of, right? So Article 2 was amended, and it says a consumer can reclaim layaway goods. There's also a bankruptcy code provision that says you can get up to $2,700 worth of stuff. So if you buy it but you don't take delivery, you do it on layaway, you still beat the secured party. You're still a buyer in the ordinary course. Okay? That's D. So there's no circumstance in any of the questions in 82 where the buyer loses. That's the essence. Buyer always wins under problem 82. What are you doing over the Problem 83. Now this one I want to chart out a little bit so we can understand who's who. Okay? Okay. Deering is a secured party. Canbro is the buyer. Mill Fabrics is the seller. Okay. Deering sells fabric to Mill Fabrics. Mill Fabrics grants a security interest back. Mill Fabrics sells fabric to Tanbro. That's the transaction. Is Tanbro a buyer in the ordinary course of Mill Fabrics business?
Yes.
Okay. Why do you say so?
Well, it was like common practice in the textile industry, and I think that they had been doing it for a while. Like it was ordinary practice for them to do that.
Okay. Who has possession?
Deering does.
So let's look two different places. Definition of Article 1 of buyer in the ordinary course. Does a buyer in the ordinary course have to take possession? I see some nodding. Those of you who have Article 1, look up 1201B9. Does a buyer in the ordinary course have to take possession?
I don't think so. I'm not sure.
Most of the way down. Only a buyer that takes possession of the goods has a right to recover the goods, maybe a buyer in the ordinary course of business. Did the buyer take possession?
No.
No. Further, take a look at 9317E. .317 does allow a buyer sometimes to win, but it says, is it E? Is that the one I want?
It's 320E.
Yeah, 320E. Sorry, 317 is the one. Yep. What does 320E say?
It says goods in the possession. It says subsections A and B do not affect the security interest in the goods in the possession of the secured party.
Is the secured party in possession of the goods?
Yes. So A and B do not apply.
So no buyer in the ordinary course protection.
So can we rewind real fast?
Sure, of course.
With Distortion, the TV, and Betty put the TV on layaway, but layaway they keep the TV.
Yes, who keeps the TV?
Distortion does. The
Yes.
store.
Who's the secured party in that first problem?
Oh,
Who's the secured party?
it was the other people.
The bank, ONB,
Yeah,
right?
That's right.
Yeah. Okay. 317E applies when the secured party perfects through possession. And the definition also says you need to get possession. Okay, 1201A9 says to be a buyer in the ordinary course, you must get possession. Tanbro is not a buyer in the ordinary course. I'm writing BOIC and I'm crossing it out. And it's below the, I know you guys can't see it. Good, okay. That's problem 83. The security interest held by Deering is protected by possession, 9317E. Sorry, 320. I keep saying 317. 320E. My mistake. 9320E. If the security interest is perfected by possession, 9320E says 313 still applies. Is that fair? If you're Tanbro, does your seller have the goods that you want to buy?
No.
Shouldn't you ask the question, where is it? That's a reasonable question. Why don't you have possession of the stuff you're selling me? Okay. This 9317E was put in there. 320E, damn it, sorry. 9320E was put in there because this case is an actual case, and they said Tanbro wins. And banks freaked out. They're like, oh my gosh, we've got possession of all this stuff. How can we possibly lose? They got the drafters of Article 9 in the revision in 1999 to change the law. They now win, okay? And, again, I think I said this at the beginning of the semester, but maybe not. It's a good time to say it now. If you're not sure, the bank, well, no, that's file. That's absolutely right. If you're not sure who has priority or who wins, probably the bank. That's your default. The bank wins unless you can come up with another reason. Here the bank wins. All right, that was 83. Let me just take a second to explain the limestone case. There's really only one issue in this case. Who has possession? Possession is the definition of possession in the case determines the entire outcome of this case. Why? Because if you're a buyer in the ordinary course who takes possession, to be a buyer in the ordinary course, you have to take possession. If you take possession, you take free of an existing security interest. Who has possession? Does the buyer have possession in this case? What's possession? You studied property law. What's possession? What does it mean to possess something? Sure, that's a good definition. Control, title. Does the buyer in this case have actual physical possession of the goods? What are the goods in this case? Ag lime, right? And where is the ag lime? It's at the quarry in a big pile. So first, it's fungible goods. So how do we know what the buyer owns in that pile? If I'm the buyer, I want my stuff. How do I know what is my ag lime? You have to write your name on every little piece of ag lime? Do you understand what agricultural lime is? It's rock, but it's little tiny pieces of rock that you spread around on the ground to help fertilize. So are you going to write your name on every little piece? Does that seem practical? So how do you know how much of that stuff is yours? And what does the contract say? How do I know what I have a contract. What does the contract need to say so I can find my stuff? Yes, by weight. Exactly. The practice in this business is for the seller to keep possession but keep record of how much weight of ag lime each buyer is entitled to. Does this fact pattern fit 9320? 9320E. Does the secured party have possession of the ag lime?
Yes.
Who's the secured party? All right, I'll chart it out. Help us out here. UB, WL, and I think there's one of the sellers is named I forget what that stands for. Right, so that's the buyer. Where is the ag lime located?
It's at WIL. It's at the quarry that WIL owns.
Actual physical possession, right?
Mm-hmm.
Is this the secured party? Can the debtor have possession for the benefit of the secured party ever? No. 9320E does not apply. Now, is and I forget what that stands for. That was in my notes. Are they a buyer in the ordinary course? You have to have possession to be a buyer in the ordinary course. What is possession?
Control.
In the case, what kind of possession do they ascribe to the buyer? Somebody said it earlier, I heard it. Constructive. Now, we all know that when a lawyer says constructive, they are lying, right? It means they don't actually have possession. We're deeming under the law that they have possession. Because the actual physical possession is here, but not here, but they're saying they have constructive possession. And how can that be? They have a case, right? Under the law of the state, they have said that when the seller retains the goods under these facts, the seller is holding for the benefit of the buyer. It's constructive possession by the buyer. Therefore, the buyer can be a buyer in the ordinary course. Therefore, 320A can apply. That's the logic of the case. It all hinges on the definition of possession. Who has it, and does constructive possession work?
So with constructive possession, because I know you said it was sort of fact-based in this scenario, in this case it makes sense because it's not easy to hold. You need a lot of area to hold 13,000 tons of anything. So if it was, I don't know, like a TV or something like that, and the seller was holding it for you, could you have constructive possession of that?
The layaway in the first problem is kind of like this, right? The layaway rules of the first problem are kind of like this constructive possession. Yeah. So Article 2 creates a circumstance where the buyer who has entered into a layaway agreement with the seller has a right to get possession, and that possession beats the secured party, but it's still a buyer in the ordinary course. Yeah. Okay. Essentially, but it's not called constructive possession, it's Article 2 possession. The layaway counts. It's as if you were a buyer in the ordinary course, had taken possession. You have a legal right to claim the property back, so therefore. Okay, this didn't say it was on layaway. That's not in this case.
Right.
Yeah. All right, so let's move on to problem 84. Octopus National Bank has perfected the security interest in all cars. Okay, I want to stop right here. How would Octopus National Bank perfect a security interest in cars held by a car dealer?
Inventory.
Yeah, and how do you perfect an inventory?
You file.
It's cars. How do you perfect a security interest in cars that are inventory?
Fine.
No! That's why I asked the question. It's a trick.
Is it on?
If you look at 9, I'm sorry, let me just double check here. 3, where was it? 312. If you look at 9303, comment 5, and then look at 9311D, you'll see that perfecting a security, so 9303 is the section that covers certificates of title. Comment 5 says, section 9311D provides that a security interest created in inventory held by a person in the business of selling goods of that kind is subject to the normal filing rules. Compliance with the certificate of title statute is not necessary. So a car dealer does not need to get their, a lender to a car dealer does not need to get their security interest listed on the certificates of title. They file a financing statement. And that's confirmed under 9311D. 9311D says, during any period in which collateral subject to a statute specified in A2, under 9311, remember that would be the certificate of title statutes, is inventory held for sale, and that person is in the business of selling goods, this section does not apply to a security interest in that collateral created by that person. You don't have to follow the certificate of title laws. So that's not in this question. I wanted to make sure that you guys knew, remembered that. Okay, so, problem 84. What's the problem in 84? Smiles owed $5,000 in past insurance premiums and exchanged the value of that debt for the car. Is Smiles a buyer in the ordinary course?
No,
Why not?
he didn't give new value.
Bingo. That's all this case. That's all this problem is. Existing debts exchanged for acquisition of goods. That transaction, the buyer is not a buyer in the ordinary course. 9328 doesn't apply.
What's the one that we did Wednesday where there was some situation where waiving a debt was seen as giving value?
Oh, it is value, so you can get a security interest. A security interest can be supported by the granting of a security interest in an existing loan. So you can get a security interest and become a secured party. You know, you're an unsecured party, and then you get the debtor to sign a security agreement. You become a secured party in that loan. That loan is covered. But you can't be a buyer in the ordinary course of business if, right? You're a buyer, it's value. The contract is a contract for sale. You're just not a buyer in the ordinary course. That's the limitation, okay? An existing debt under Article 1 is value to support, is sufficient value to support transactions under the Uniform Commercial Code. But the definition of buyer in the ordinary course does not allow old value and existing debt to create a buyer in the ordinary course status. Furrowed brow, want to make sure you're okay. Good, excellent, all right. So that's all this problem is about. My little review was just, there's a special rule for inventory. You file to perfect a security interest in goods that would normally be covered by a certificate of title. You file to perfect in those, and I wanted to review that. Okay, 85. Arthur Greenbaum bought a new car. He bought the car from Lori's Car City, who got a purchase money security interest. He then sells the car off his lot. He happens to also be a car dealer. So the individual buys a car from another car dealership, grants a security interest in the car. That's a purchase money security interest, right? What is the car to him when he buys it? Consumer goods. But he is a car dealer, and he takes that car, his car, and parks it on his lot. And then he sells it. When he sells it, right when he sells it, what is it?
Inventory.
Okay. Does 9320A apply to that sale? Now remember, 9320A is normally a circumstance where we have inventory sales. But he didn't buy it originally as inventory. He bought it for personal use. Is the buyer from him at his car dealership a buyer in the ordinary course? Is he in the business of selling cars? Did she give new value? Did she take possession? Who created the security interest?
Seller.
Does she take free of the seller's security interest? She wins. Even though Arthur bought the car for personal use, he sold it as inventory, and therefore the buyer who gave new value took possession, didn't know that it violated the security agreement, because it probably did. It probably states that you will not sell it without us knowing. And he created the security interest. All of the requirements for buyer in the ordinary course under 9320A and 1201A9 apply. The buyer here is a buyer in the ordinary course and should take free of the security interest created by Arthur. Does that make sense? There's no law that I can see that would change this outcome. All of the requirements for 9320A are met. Therefore, she takes free of the security interest created by Arthur.
So because the language is kind of confusing. So an individual that walks off the street into Walmart and buys a TV, like you said in your presentation online, they take the TV free, whatever, of the security interest of Walmart's creditor. Okay, even though that individual is not selling that good, because when it says buyer in the ordinary course, like it seems like you're buying it, so you're gonna turn around and sell your.
Yeah, right. That's a little confusing. It's not a buyer in the ordinary course of your own business. It's a buyer in the ordinary course of the seller's business.
Okay.
You're buying from a merchant that sells those kinds of goods. In my lecture online, I said, well, what if Walmart turns around and wants to sell its trucks, delivery trucks? It doesn't sell trucks. So they're not being sold by Walmart in the course of Walmart's business. No buyer of those trucks is a buyer in the ordinary course. Here, Arthur does sell cars. Is it Lori, I think is her name, or no, Ann, whoever the buyer is. Ann buys from Arthur, and Arthur sells cars. And she gives new value. And it's inventory when he goes to sell it because he's selling it off his lot. Right? It fits all of the requirements of Article 9, of Article 320.
If you just told her, like, this is my personal car, then it wouldn't be a buyer in the book.
I don't know. See, so
That's kind of flimsy that he just parks this, like, you can't park his car at work.
well, it is his work. He's parking it at work.
That's what I'm saying, so like, just because he owns a car lot, he drives his personal car and parks it at his job, it then becomes inventory.
Now we have facts that suggest maybe the buyer knows that it's not an inventory sale.
Yeah.
Yeah. Okay. So we are at time. The next question is one that, let's see, that was 85, right? I'm just going to spend 1 minute on 86 because I'm never going to test on 86 because it requires you to use law outside of Article 9. So I just want to tell you what they're talking about. In problem 86, you have someone buying promissory notes. There is a law called Article 3. Did anybody here take commercial paper? Nobody. See, this is why I can't test on it. Article 3 says if you buy commercial paper as a holder in due course, you take free of any claims that other people in that commercial paper might have. So if you buy it not knowing that there's a security interest in it, you will take free of that security interest. But that's Article 3 law. I will never test you on that. Okay? Promise. Right? We'll never test you on that. And that makes everyone in this room happy. Question 86 will never appear on any exam in this class. What you should know about it, because a holder in due course is kind of a really great status that a buyer of commercial paper gets. Article 3. Okay? We will finish up buyers next time. I am substantially redoing the reading for next week. There's a lot less. I'm cutting a lot of stuff out because I'm just looking at it. I'm never going to test on it, so I don't need you to spend any time on it. So we will have more than enough time in class on Wednesday to cover the end of this class and what I'm going to have you read for next class. So we're not going to meet on Friday. Okay? Thank you. Have a very nice weekend. Anybody doing anything fun? Okay.
Sorry, Professor.